Yes, welcome to the No Stay Project here on just my YouTube channel for today, and I apologize for that. I tried to get the LRN stream going, but that was a complete and utter train wreck from my end. Apparently, another tech issue on the No Stay Project, which we're kind of used to that by now. But this was pretty disastrous. It's just one of those things. It's just, oh, I'll get it straightened out. And even though, the network, Ian, great guy, had, we tried, but apparently I couldn't use my mixer. It was horrific because of the static. And again, this is the No Stay Project for the 23rd of March, 2019. And I appreciate everyone tuning in. Uh, just I updated the drivers. I can't stand having to use a Windows machine. I mean, as much as I hate Mac and think it's one of the worst companies in the world, overpriced. The thing is, I have a hell of a lot more trouble with these Windows machines. I had to update the drivers. It was I crossed everything off. The mixer worked just fine on the other computer. There wasn't all this static. And so I narrowed it down. It was the drivers. I updated the drivers. Man, the you can hear it. The audio from that was perfect. It was right where it should be. So unfortunately, what updating the drivers did was it wiped out all of my audio programs. I don't have any. I don't have any playback from So the Audacity. So I update the Audacity, and still nothing. And I figured a few minutes before the show, okay, I what I'll do is I'll record on. You don't have to use Audacity, so I used Adobe Audition. I got the exact same error. I couldn't record, so we tried to get it straightened out. But hey, I appreciate people starting to file in and tune into the big show here today. One of the benefits, I guess, is there's no commercial stuff to cut. So I know the last time I did the show a couple of weeks ago, got a pretty good response to it. And you do have the option to edit YouTube videos now, but you can't go in and, at least I don't know. Maybe somebody can give me a link to something where where you can just clip out. Let's say, because I have 12 segments of the show normally, and I don't talk during the middle, during the breaks, and so it's easy, like with Audacity, something to just see the flat line, or here with you just cut that out. So editing is fairly simple that way, to cut all the commercial breaks out. You don't seem to have that option to clip out the middle part of YouTube video, so it's not sophisticated enough yet. So which is why, anyway, hopefully soon. I gotta let everyone know I appreciate the support of the show. It is really appreciated. If you're able to help support the show, please do so. It's markstevens.sells.com. That's markstevens.sells.com. You can just go to my website, markstevens.net, where you can also get Government Indicted. So, there is a book. Government Indicted goes through a whole model on how to successfully defend yourself against bureaucrats. How to effectively, I say, it's always how to effectively defend yourself, because what we always are able to do, at the very least, we are able to show that these proceedings in court, especially traffic and taxes, we're able to consistently show that they are grossly unfair, that they can't even begin to comply with their own damn rules. Their own rules. So let me give me a second here, since I'm going to give the caller name out. But the caller numbers. Boy, I'm going to be everything to get through a show today. Well, I better keep that muted, because I may get my troll to come in. The number is 218-632-9399, 218-632-9399. Passcode is 2020. If you want to talk about anarchy, government abuse, or effectively defending yourself, which is what I was talking about before, because I will be the first to admit it's unorthodox, but the email announcement. Well, for those who think they're tuning into a show that's been on for an hour practically. That's not the case, Nelson. I just started the show. Although it's really nice to know that you're getting the email notifications because uh, I'm going to err on the side that YouTube, like Facebook, if you have an unmonetized channel like this channel, that uh, they don't send notifications out to everybody. So I saw a video the other day where apparently, like on a FaceTube, on a FaceTube, FaceTube, on a Facebook feed, that only 7 to 9 or 10% of your friends or followers will actually get new content, and that's because they're pushing for you. And I've this I know is true. They are always pushing for you to pay so that more of your subscribers will actually see new content. And I think that is probably something that is okay. Well, well, I'm not saying no one's getting the notifications, but I mean, 100 notifications out of 15,000. That's not so good. So it's not so good. Well, I'm having a good one so far. Well, now because I'm able to do the big show here. I was a bit tense for that first hour and a half before the show which started an hour ago, supposed to start an hour ago because I had such bad tech issues. But to get back to the material of the big show over here, I did have somebody contact me. I have not posted it. I do have the document. I haven't even looked at them. It's been one of those weeks. Somebody else has gotten some tickets thrown out, and I'll get that posted. I haven't gotten the other documentation yet from somebody, so we'll get that posted. But when it comes down to it, there's already a huge chunk of the wins that we've had in the success stories have already been posted at markstevens.net. And so even if I didn't post anymore, there's sufficient evidence there that the material is effective, and that we've been able, and that's because we've been able to replicate the success that I initially had, and with other people just locally here, we've been able to replicate that in all 50 so-called states. We've been able to replicate it in a bunch of the provinces up in Canada. We've done in England, we've done in Australia and New Zealand. And for those who are new, and those tend to be the more vocal ones on the comments, I got to ask, you got to, if you disagree with something that I'm presenting on the show, if you agree, you like the material, then let me know in the comments, especially if you disagree, which is one I'm going to talk about today, which I'm leading to. I'm getting to that. So what's especially great about what happened in England with Helen that time was she did strike the root and was attacking the allegation that they had jurisdiction just because, because the laws applied just because she was physically in England. And she not only challenged that successfully, and that there was no evidence, but because there was no evidence and they wanted to proceed anyway, nothing was going to stop them. In a conference, a case management conference, they were able to not only get this frivolous ticket thrown out, but costs were awarded. I can't speak. Just like get a hand dirter. I got a good brain, good genes, maybe the best. So that's big. So a lot of critics, especially one has been very vocal lately. I have to disable the notifications that come on my email, so I don't have to actually read this. But this one, I think it's funny, fun, to explain why this particular commenter is just wrong. How do you explain in Helen's case, which she was on the show, and we have the documents at markstevens.net, that costs were awarded. I did it again. There were costs awarded. It's not even a Long Island thing. That's just I don't know. Maybe I should get high. She had costs imposed against the prosecutor's office because they proceeded knowingly without evidence of jurisdiction. So there's a lot of excuses, a lot of comments and criticisms that get, about some things that are tossed out. Yeah, some of them are valid because it just, we can't necessarily prove definitively. Circumstantial evidence strongly suggests, but here it's big because it's not just an issue of it was dismissed. You still now have to explain why the judge, the magistrate, would have awarded costs against the prosecution at the case management. Because contrary to what people will say and critics, and I'll be the first to say it's unorthodox, you're not going to learn it in law school. In law school, you're not taught to challenge the very foundation. You are taught to just accept that the prosecution's claim or the IRS's claim or a cop on the beat, one of these 5-year-olds with a gun, that their claim, that's all it is irrefutably true. So irrefutably true, as if from the hand of Odin himself. Just questioning it is frivolous. Frivolous. If they can make that, this is something that the critics don't seem to understand, or maybe they do understand. They just they don't care. That police officer who stops you is making a legal claim or legal determination. He is trying to apply the law to you in his mind, which apparently lacks critical analysis skills and critical thinking skills. The ability to just question something instead of just taking everything that somebody tells you is true. Well, if they're willing to pay me and I got a pension, why wouldn't I think this is true? They are saying that the laws apply and you violated them. Any reasonable person accepts that that's what is actually happening. And so I have been criticized by this person that they're claiming that jurisdiction is a question that is not up for dispute, period. That the question of jurisdiction was settled with the 10th Amendment. So, admittedly, being that I was on the phone, I did make a typo in my response. And that was that the 10th Amendment wasn't ratified until 1791. And I had mistakenly put 1775, and when it should have been July 4th, 1776. But from 1776 right up until November of 1791, the states were exercising jurisdiction. So if the 10th Amendment is the basis of the state's jurisdiction, what were they doing from 1776 to November, into December of 1791? I mean, it's a stupid argument. It's absolutely devoid of any kind of rational investigation, and it's just stupid. And it's, I don't know, maybe is it bad or is it worse or the same as a tax agent that said to me that the 14th Amendment settled the issue of jurisdiction. But the 14th Amendment wasn't until the mid-1860s. I had to mention to this. Do you have to really point these things out? The 14th Amendment was in the mid-1860s, 1866. It was after the war, between 1865 and 1867. The states had been already around for 90 years. 90 years! So if the 14th Amendment is the proof of jurisdiction and it didn't exist for 90 years, see, it's just the same stupid type of logic that you get when you confront a bureaucrat in front of a whole bunch of people, such as Scott Bales, or, like who I confronted publicly, or Bill Montgomery, who wants to work with Scott Bales on the Supreme Court, the Arizona Supreme Court, where Bill Montgomery, of course, being the Maricopa County attorney. and that their claim that to support their claim that the laws apply to me because I'm physically in Arizona is because they put the other people in prison. That doesn't wash. That doesn't make any sense. And of course, when I asked him to exactly how, because yes, I did, and my follow-up wasn't as good as it should have been. I asked him in a rotunda later. I asked, hey, exactly how does putting other people in prison prove the laws apply to me? And and a big flaw in that logic, that's a non sequitur at best. You have to look at the if putting people in prison is evidence that the laws apply. Well, there had to be a time, and there was a time where right after they passed the Constitution and their code, that no one had been charged with a crime yet. And so that first unlucky son of a bitch, they knowingly according to their logic. I don't believe this for a moment. This is just stupid. I'm trying to explain the logic of this ridiculous argument. That the first person that they prosecuted and put in prison, they had no evidence of jurisdiction. Once they prosecuted and put him in prison, then they claim, now we got the evidence that applies to everybody else. Oh my gosh. And instead of saying Scott Bales gave a ridiculous, the man's a Harvard law graduate. And instead of attacking that unbelievably stupid argument, that ridiculous claim that putting other people in prison proves the laws apply to me, they pigpile on me. Why? And this is especially for people who are new to this, because you're challenging the orthodoxy, or you're challenging something that they make their living on. So of course they're going to mock you. They can't actually prove their proposition. They can't prove it. So they mock it. Well, Mark's an idiot. It's just like with the IRS. The IRS, they will scream from the rooftops, frivolous, as if Odin himself has told them, if anyone disagrees with thou, my servant, yell frivolous like an autistic idiot. And the more times you say frivolous, the more you will be paid. What is truly frivolous, for those who are not aware, is when you make an argument and you know you have no proof. And you even argue you don't even need the proof. Am I actually on the Discord server right now? Well, if I'm transmitting on the on there, then hey, there's no problem with that. Don't know if you guys on Discord. Yeah. Hey, let me know. Am I actually Am I on the Discord server right now? Am I? Mark is. Well, okay. Either way, hey, that's pretty cool. So you can listen to it on the Discord. I didn't realize I didn't close that out. So you are not transmitting. Oh, okay. Maybe. Okay, not a problem. I thought maybe because the microphone. Maybe. All right. Well, so I'll get to the phones in just a second. So the issue of jurisdiction, according to this YouTube commenter, has already been settled. And I think this is absolutely comical, because if the issue of jurisdiction was already settled, then why would there be Rule 12b motions to dismiss for failure to state a claim upon which it could be granted? Why would there be motions to dismiss for sovereign immunity when you can't claim sovereign immunity when the question of jurisdiction was settled with the 10th Amendment? And they sound like somebody, and I said, I've already made my case. I believe I already made my argument. And I've done it not only on this show, every single time, twice a week, most weeks, for a decade. I have articles about it. I have calls of shame verifying it. I have a whole damn book just in the last few years, Government Indicted. So I'll make my case again. The issue of jurisdiction is settled in that there is no evidence of jurisdiction. Not that there is jurisdiction. They're just men and women forcing strangers to give them money. It doesn't create, and by forcing people to give you money, it makes you a criminal. That is wrong. It is immoral. It is unethical. It is wrong. It is morally reprehensible. And because it's wrong, it doesn't create obligations of allegiance and protection. And those are what make people citizens. Because what makes someone subject to the laws is this notion that when you enter the realm, then there's an unwritten law or unwritten agreement that you are subjecting yourself to the protection of the sovereign, and in return for the protection of the sovereign, you have pledged that you will abide by his laws. Well, the dude may abide, but not abide by such a stupid thing. All those within the realm are entitled to the king's protection. There is no duty to protect you. The fact that they are willing to, it's like saying everybody that walks into this neighborhood is subjecting themselves to the protection of the Gambino crime family. And you have to pay your protection fees. So, ridiculous. Absolutely ridiculous. There's no evidence. The facts are dead set against you if you are arguing your mere presence. Yeah, blame the victim. I love that. Your mere presence does not negate the fact that they are forcing perfect strangers to give the money. And because of that, what I just said, there couldn't be any evidence that their laws apply. You can ask them and they will tell you. Maybe what this critic should do is listen to my call of shames, especially the ones dealing with prosecutors and police officers who are and tax agents who are actually making these attacks. The ones who are not just keyboard warriors. They're actually attacking people. And so I'm going right to the source. And I have dozens of call of shames with the actual bureaucrats that you think have jurisdiction admitting. I love the one in Washington, the husband and wife team, insisting that the laws apply just because Mr. X was physically in Washington. And I asked her what facts. She couldn't tell me exactly exactly why do the laws apply just because he's physically in Washington. And they just do. But though, again, I like gearing this all towards people who are new to this, because you're going to see these comments and you shouldn't feel discouraged. Who is really in the wrong here? The one challenging the assertion or the one making the assertion, and when questioned on that, says, it just does. It just does. I've got that multiple times. But what was so great about that particular call was how exasperated she was. She was, they just do, or it just does. So no, the issue of jurisdiction is not settled by the 10th Amendment, because if you have to have evidence that the 10th Amendment, that the Constitution, the federal Constitution itself, is there any evidence that applies? And Lysander Spooner, if you haven't heard, no treason, the Constitution, no authority. No, there is no evidence. And I've got hundreds of calls verifying that. So what is really ironic about people like this critic or this poster, I don't think she rises to the level of a critic. She's just a YouTube commenter. The irony when they cry frivolous, or when the IRS cries frivolous, we have two IRS agents on record I've spoken about before, on record admitting to not only not having any evidence to support their claim of jurisdiction, but also that they don't need evidence. Now, the laws are clear, due process, they're not enforced, that they have to have proof. Otherwise, it is what's called a naked assessment, or it's just not factually sufficient. An assumption that you build the rest of the assessment on, it's not sufficient. Arguing without evidence and that you don't need evidence is the definition of a frivolous argument. And yet they project that on us. It's just like Captain Bonespur, who would have ran into Parkland even without a gun to protect those kids. Anyway, look, I got to get to the callers. We're starting to get lined up. It's an issue that's, it's so frustrating because they are projecting, like I was saying, the Cheeto. Everything he accuses other people of, he's doing. Disloyalty. The man has been divorced twice, has cheated on every single one of his wives, and yet he screams that everybody else is disloyal. I mean, it's just ridiculous. And that's why I mentioned before, it's like the IRS is getting paid, or their attorneys are paid by the damn word. At every time they use the word frivolous, they'll get $100 bonus. So they say it as many times as possible. And then you get these people on YouTube who, without any critical analysis whatsoever, just spew in this verbal diarrhea. Frivolous, you're wrong. And in the one, it's the extravagance, or it's how lucrative that what I'm doing is so lucrative that I can't possibly tell the truth to my audience. A truth to an audience that is free to call and challenge me on this. So if there is a critic there listening, instead of banging away at your keyboard, call 218-632-9399. The passcode is 2020 and confront me in real time. I don't even know. I don't care about your real name, but at least address the issues in real time instead of hiding behind a keyboard. Because otherwise, YouTube comments are worse than Facebook comments. They almost universally have no merit whatsoever. So look at things critically, analyze it, see if the facts and the logic add up. And if you actually think that the laws do apply, try to prove it. Do what even a Harvard law grad could not do. Even it was admitted by Robert Diab up in Canada. The laws, the applicability of the law, and this is a PhD in law. He's not stupid. He knows what he's talking about. The applicability of the law is not based on evidence or argument. It is a blunt assertion of power. Now, maybe you love authoritarianism. That doesn't mean that a blunt assertion of power is factually sufficient to prove that their rules apply. So if someone comes into a bank with a gun and says, I'm going to unload this on anybody who doesn't pay attention and listen to me and follow my instructions. Oh, well, I guess we're all now obligated somehow to listen to this guy. Critically analyze it, know your logical fallacies, and when you see these unbelievable double standards, such as cops being able to kill people even with negligence and not being charged at all, but if you or I so much as ask a question to a judge that they don't like, you go to jail. It's disgraceful. So we'll go to the phone, see if you want to join me. The number is 218-632-9399. 218-632-9399. The passcode is 2020. But this is the way it's always been, Mark. Why are you so childish? Well, because you got to keep your sanity through all this. You got to take it with a grain of salt, and you gotta have a good attitude, and it helps to have a great guitar. Oh gosh, look what I did. Completely forgotten, left it plugged in. All right, let's get to the calls. We've been going for a bit here now. We've gotten it. It looks like a Skype caller. You're live on the No State Project. What's your name? Where you're calling from?
Hey, Mark. How's it going? This is Imran.
Hey, Imran. How's it going today?
How you been?
Yeah, I was doing okay until the beginning. What I thought was the beginning of the show, but things have smoothed out for now, and we seem to be doing pretty good.
Well, I have several questions. One is I have this issue in regards to I was arrested a while ago in regards to when I stopped my car at a parking intersection or an intersection. The police officer claimed that my bumper was protruding into the crosswalk by about a foot or two. And anyways, so they, I got charged with failure to state name because when he's asking me for my information, I was trying to call the police and ask for a supervisor. And so there's a hearing yesterday in which I already submitted paperwork ahead of time, talking about issues of jurisdiction and so forth. And then the prosecutor, like a day before the hearing, wrote a motion to strike those documents off the record. And then the judge agreed with that. So,
wow.
By their own rules, aren't they, when they submit a motion, shouldn't I have time to review the motion and respond, like 20 days or something like that, which I wasn't given, right?
No, well,
so that wouldn't that be a violation of due process?
Notice an opportunity to offend is the hallmark of due process. But let me ask you, what was the basis of the motion to strike?
Oh, she was claiming that it didn't. Well, you know what? I have it right here in front of me. Well, I know just before we even get to that, I was claiming that this prosecutor was fraud because the prosecutor in the court were recognizing her as an attorney for the state of Arizona. And then I asked this individual if they were employed by the Arizona Attorney General's office, and they didn't respond. And so I said, well, if you're not, did you submit paperwork from the Arizona Attorney General's office stating that you can act on behalf of the state of Arizona? And they didn't respond either. So I said that this person was acting under fraud, trying to represent the state of Arizona when they're not, they didn't submit any paperwork. Well, anyways, they kind of
well, Imran, I'm sorry.
Didn't respond.
Well, yeah. I'm familiar with this because it's something that I used to do. You have to, if you're going to go down this road, which you can't do, everywhere. I know you can do it in Arizona. And let me just bear with me, everyone, for just a moment to explain why Imran's doing this, or at least why I would do this. The motor vehicle code in Arizona is very clear that only the attorney general can represent the state in enforcing the motor vehicle code. It's right there in the beginning of the code. Now, it may not even be there anymore because it's been a long time since I read it, but this is the way it was, at least. So hopefully it's still that way. They have laws that say if they're going to do something, it's in the regulations and in Title 41, I think it is. If they want to, they can issue a delegation order allowing county attorneys and city attorneys to act, to do the, what the attorney general is charged with doing. So what you need to do is you need to first go to, I think it's the Secretary of State, and you have to go to also the personnel or the city clerk or the county clerk, find out from them, do a formal request if there is a delegation order. Then when there is when they give you documentation that there is no delegation order, now you've got your proof. You've got actual hard, you've got documentary proof that the law requires A and B and C. They didn't do it, and here's my proof right from the Secretary of State themselves. They said there's no delegation order on record, and it's right there in the code. They're supposed to have it. So,
right, but the thing is like what you and several other callers have talked about before is they just ignore all that and then they keep moving, right? So you're saying that I would need to bring that up in the appeal, correct?
Well, if they ignore that,
they're just gonna. You're just saying, based on what you and like what I've seen with my own eyes and what you've seen with your own eyes and what your callers have seen with their own eyes, is any issue you bring up, even if it's legitimate, like jurisdiction or, fraud or whatever, they just ignore it and move on, right? So
Typically,
you're
yes.
saying I
Yes.
need to make a record of this so I could tell the appellate judge that, hey, I brought this issue up. They didn't address it properly, and they just kept moving. Correct?
That's what we like to do. So hopefully they're going to be they'll be responsive to that instead of just continuing to ignore that. I will tell you that we did have, for example, here in Chandler, where Rebecca was able to get an acquittal on one of the two charges. Yeah, we've never had any success. She got a full acquittal, for heaven's sakes. It's still not enough for these people. That's because their mind is made up. It's not critical analysis, just being an internet douchebag. And so what happened was they would, and I've mentioned this before, but hey, we got new people. I'll repeat it. She asked the police officer who made the determination, each police officer, but she, especially the one that actually made the determination of probable cause, she asked him on the stand on cross-examination, did you determine on your own that just because I'm physically in Arizona that the laws apply and you had jurisdiction to investigate and probable cause to, arrest me? And he said, yes. And so when she followed up, what facts did you rely on to show that that was true? That's when the prosecution objected that it called for a legal conclusion, and the judge sustained it. Now, she argued pretty good, and a jury got to see it. They got to hear the prosecution say the witness was incompetent. They probably weren't drawing a distinction, like some of these anal retentive lawyers do. But bottom line was the judge allowed an objection that was off point. And the judge was not going to. But the thing is, Patricia Starr, I'll never forget that judge's name. Patricia Starr on appeal repeated the lie. So even if, and unfortunately, the same thing happened when we appealed an IRS case in California. The trial court judge lied, said that we had no evidence, even though there was a CD of the actual evidence. The appellate panel lied. So I'm not trying to discourage people. We just have to know that even when you do things right and you have hardcore evidence against them, that doesn't mean they're going to do the right thing. It's not because you and I are anarchists. It's because they are dishonest. And
right. So I guess, well, here's what this individual wrote. I put a special appearance notice on the record, and they were stating that actually their Arizona Rules of Criminal Procedure 35.1 states that all motions must include precise legal point, statutes, and authorities relied on. And right there, she's incorrect because what I filed was not a motion. So, and then it says defendant's notice cites no legal authority. Not only is a lack of legal authority a violation of the rules of criminal procedure, but also makes it extremely difficult for the state to respond appropriately. And once again, she's not the state; she's a city attorney.
Well, yeah. Well, she's acting on behalf of
statute or legal authority. Go ahead.
I'm sorry. I hate interrupting. Just that she's acting on. She's not saying she is the state. She's saying she's counsel for the state. That the state government, is the the plaintiff.
Right. Which I asked for evidence of that, and she couldn't provide any, and so the judge had to bail her out.
Sure. But what do you mean that you didn't file a motion? If you filed my motion to dismiss, that certainly qualifies as a motion, and there are certainly legal authorities that are cited in there.
Right, but there's also a problem with that is like if you file a motion, aren't you making a general appearance?
You got to read the very first part, the very first line of my motion to dismiss is that I, Mark Stevens, and it says not appearing but participating on a threat, duress, and coercion. I make it very clear I am not participating. I mean, I'm not appearing. I just spoke about this on one of the shows, and I think the Wednesday show. So I have the graphic in there with the legal definition is of appearance. No. They may take that still as a general appearance because they don't recognize a special appearance in criminal court anyway. I just want to let them know that I'm not appearing. You're dragging me. You're sometimes literally dragging me in here. That's not an appearance. This is not a general appearance. This is call it a plea and abatement or a demur motion to dismiss. It's not an appearance. They'll again. I understand that they want to argue that it is, but that's going against reality. They're forcing you on a threat of jail or a death warrant to get you in, to get you to participate. So that doesn't sound like an appearance to me.
Right. So anyways, she finishes by stating the rules of criminal procedure require motions contain legal authority. Defendant's motion, which once again, it wasn't a motion, it was a notice, should be struck. And so then that was what she filed one day before the hearing. And then I never got it because it was the day before the hearing. And so I showed up to the hearing and she said, well, like I sent it through the mail. And then the judge says, okay, well, those documents were struck from the record that I filed.
So does that include my motion to dismiss?
What's that?
Does that include my motion to dismiss?
No, it didn't.
Okay. Well, I guess the easiest thing to do would be to edit it properly and get the thing filed.
Okay. So also another question I had was I asked for if there was a verified complaint, and that's put in an exhibit about a Illinois case, a Supreme Court case, saying that basically they overturned a man's guilty plea because there was no lack of verified complaint. And then the judge said, well, that's Illinois, that doesn't apply in Arizona. So I was wondering, do you know the requirement for a verified complaint?
Well, it has to be under oath. It's supposed to be under oath, and in Arizona, it's certified. So I think it acts the same way.
So you're saying like a traffic ticket, like a criminal traffic ticket is a verified complaint?
It's certified. And in Arizona, that's sufficient. Now, for a long time, they needed a verified complaint in California, or the court explicitly did not acquire jurisdiction. Then the courts decide, so if you requested or said that there was no verified complaint, they could just have the police officer sign a verified complaint and they prosecute you, or the cop, couldn't be bothered to do that. They've since changed that. It's been like that for over 10 years, if I remember right. So what they did was they just said that what it gives you at the stop counts as a verified complaint now. It's no different than the wordsmithing they did with the habeas corpus, where all the habeas corpus, statutes, or parts of the Constitution, wherever it originates, they all say basically any restraint of your liberty, you can file a habeas corpus to challenge the legality. Any restraint of your liberty. These lawyers, why do people look up to lawyers for any reason other than to be just vile, narcissistic pricks? Lawyers then wordsmith that to mean physical custody only. How do you take any restriction of your liberty and narrow it down to, well, it's just physical custody? If anyone thinks that only a real state, pro-state scumbag would do something like that. Look, I got you. Somebody, if it may be in the chat, somebody please tell me why, when you have something that was proven effective, like the habeas corpus, and says any restraint of your liberty, why that would be so unbelievably narrowly construed to just mean physical custody. Why would they do that?
Right.
What honest, moral person would do that?
Yeah. What about also the issue of bona fide claim?
Well, I think that goes to
they lack a lawful bona fide claim, right? Which is what I brought up as well. And
yeah, but you gotta.
It's kind of steamrolled.
Imran, I have all this in the motion to dismiss. So what you're talking about is personam is subject matter jurisdiction, where they have a legitimate, verifiable, justiciable case of controversy, where there has been an allegation and supporting facts that the laws apply and were violated. Okay. And that there's damage from there. So in Arizona, for example, like the corpus delicti, there's the act and there's the result. Okay. Which gives the court subject matter jurisdiction. So again, I have to point this out. I keep having to repeat this. Subject matter jurisdiction means that they have subject matter jurisdiction over a particular type of case or controversy. It does not mean, like I said, like traffic. It doesn't mean they have jurisdiction over every traffic complaint. And anybody who tries to tell you that just filing the complaint gives the court jurisdiction, no, it goes back on to what this YouTube commenter said, that the issue of jurisdiction is not up for dispute. It was settled in 1791. Well, what happens when you file a complaint in the Superior Court in Phoenix against the IRS? They challenge jurisdiction.
Well, not only that, but that person is wrong, because diplomats are immune. Also, Native Americans, Arizona statutes don't necessarily apply to them.
Yeah, how's that working out for them?
I mean, there's various examples, but
yeah, I understand. And what this commenter said is just totally, it's just wrong. And we could spend more time on it, but I don't think we have to. It's ridiculous, because the first thing that they will do if you file against them is file a motion to dismiss, because there's no subject matter jurisdiction, which is exactly what is meant by plaintiff has failed to state a claim upon which relief can be granted.
Right.
They don't have sufficient facts.
I think this judge was saying that I did not challenge jurisdiction properly. And do you know what they meant by that? Like, did they mean I have to file a document, or is just me stating that?
If you don't have a copy of my motion to dismiss stuff, email me after the show and I'll get it over to you. You have to show the legal, like, it's an adversarial proceeding in Arizona. We know that. I have the Poe versus Pullman, United States Supreme Court. It's an adversarial proceeding. We know that. Okay, so that's our legal proof for why. And then the Arizona Supreme Court states that the government is instituted just to protect and maintain individual rights. Then we have other support, legal support, that about subject matter jurisdiction. It has to be the act and the result. And that's our legal basis. We go to the complaint itself and show the complaint doesn't have sufficient facts to show, an act and a result. They're accusing you of they're accusing you of being subject to the law and violating it, but they don't have any evidence to show that you're subject to the Constitution and laws. They just assume that part, and therefore it's insufficient under these standards, which we have from the U.S. Supreme Court and the Arizona Supreme Court. They're in due process type of things.
Okay. Another thing is about your corpus delicti. You said that arose from a California case, right?
No, I have an Arizona case, and that's why I've been quoting some of without giving the citation. In Arizona, and these citations are on my website. They're under the standing cross-reference. It's also in Government Indicted and Adventures in Legal Land. They talk about corpus delicti comes from years, millennium ago in England, where so that somebody wasn't convicted just on their testimony, their admission. There has to be physical evidence.
Hearsay. And
the physical evidence of an actual crime. So you have an act and a result. What they're really punishing is the result. So just bear with me for a second. There's a corpus delicti rule, and then there's the corpus delicti. They're not the same thing. The reason why they try to say it's not, that it is the same thing, is because they say, well, in a traffic case, they don't give a damn about your admission. So it doesn't come. Yeah, but the corpus delicti is an element of the crime. It is the crime. And under an adversarial proceeding, this is where the logic comes in. And in an adversarial proceeding, there has to be an antagonistic assertion of rights, or it's not an adversarial proceeding. Adversarial doesn't mean, I disagree with you. That's not what adversary means. It's unbelievable to me, Imran, how these people attack me as some kind of idiot, and they'll go on and publicly state that something is. I've had prosecutors actually do this while screaming frivolous, that it's adversarial because the defendant objects. What? Oh my gosh, the level of stupidity there. So that's the logic behind showing why the corpus delicti, the act and the result, is absolutely necessary for any adversarial proceeding, any civil or criminal. So the idea that, well, it's traffic, you idiot. What the hell's wrong with you? It's traffic. it's an adversarial proceeding, right? Yeah.
Mhm.
Okay. Doesn't it have to be an antagonistic assertion of rights? Yeah. Are you doing that in his complaint? But you violated the law. Where is your proof that it applies to me in the first place? I don't need proof. Anybody's got to see this is, I'm just acting out what actually happens and what you hear, when you talk to these people, when you look at the stupid remarks that people leave on my YouTube channel. Oh my
Mhm.
gosh. All right. Well, so yeah,
But like the bottom line though is even if you bring up these arguments, they'll just keep moving, correct?
say that again.
I mean, even if you bring up these valid points, they'll just keep on moving, correct? And usually,
They
like
can.
from what I've seen, is it's not the prosecutor, that the judge will essentially start answering questions on behalf of the prosecutor and
Yeah. Okay.
so on.
But if the prosecutor is an honest officer and counsel of the court, isn't he going
Mhm.
to say something like, excuse me, sir, I don't need you to prosecute my case for me. That's not fair. The prosecutor is supposedly an obligation to ensure due process. He has an obligation on the due process, just like the judge does. So to sit by and
Mhm.
watch the judge start to prosecute you, I think the prosecutor is just as liable for that due process violation as the judge. Because hey, if you're the one who robs the bank and I actually funded you and conspired with you to do that, I'm just as guilty.
Mhm.
If I am complicit with you in that crime, I am an accessory. So if the judge is committing the crime of obstruction of justice by prosecuting you, and a fellow officer of the court sworn to uphold due process just watches and benefits from it, I think he's just as culpable. Oh, but I know the rules don't apply to
Right.
them. They only apply to him. What are you talking about? I, you know, I'm working on a whole video showing
isn't
that.
that practicing law from the bench?
If he starts to prosecute you,
Yeah.
yeah, I would say, yeah. I say if he's actually prosecuting you, then that would be practicing law from the
Mhm.
bench. I think when a judge
And
interferes and actually starts to cross-examine or question a witness, I think at least if there's no objection, I think yeah, I think that's practicing law. Obviously, see, they'll
which,
say I can't do it because that's practicing law. Why does the judge?
yeah, now I found on the federal level that practicing law from the bench is a crime, but
Yeah.
do you know of any references where it's unlawful on the state level?
I know it's supposed to be. I can't.
Uh-huh.
I can't. If somebody listening wants to, can research and pull that up. In Arizona, it might just be a violation of the rules of court, like like
Mhm.
practicing law without a license is just a violation of the rules. It's not an actual misdemeanor like California, for example. But I don't know. It's not. It's frowned on, but I think they do it all the time.
Mhm.
It's in fact, when judges start testifying or doing stuff like you don't, well, it's a, it's an error that's considered so bad you don't have to object to preserve it for appeal. So I would say the same, it probably
Mhm.
applies there also. So, uh, okay, I'm starting to get lined up with calls here, my
Okay.
friend.
No problem. No problem.
Did we
All
address
right.
all the
Well, have a good
questions?
day.
Oh, I addressed all your questions.
Yeah, yeah. We can chat on Skype as well.
Okay. All right. Appreciate the call.
All right. Okay. Bye.
Imran. And I don't think Imran's out here anymore. Imran, well, maybe he is. I know he was with me when I confronted Scott Bales at the Supreme Court. He went first and got a lot more time than I did. I think his question wasn't as direct as mine and wasn't nearly as embarrassing to Mr. Chief Justice. So they got me out of there. Yeah, I'm fully aware the critics saying that they just didn't want to embarrass the retard, and it was for my benefit because I was embarrassing myself. That's right, because I asked a question, he gave a ridiculous response, and I was the one that was and I was the half idiot. So, yeah. Real quick, there was a comment here that obviously, if it's forced to trial, you've done something to convince the judge. I know this is in jest, that we must have done something to convince the judge there was jurisdiction. No, the judge is, I know he's being sarcastic. No, the judge acts under the impression that anyone he forces in there gives him, that he has jurisdiction over. That's not the way it works. That's not how you acquire jurisdiction. Certainly, nobody would argue that if a judge forced another judge into the court, that would give him jurisdiction over another judge. So, if a federal judge was forced into a state court on whatever charge, that alone gives them jurisdiction, that I'm going to have to go ahead and say no. The jurisdiction, unlike, is not based on the 10th Amendment. Jurisdiction is based on whether the Constitution applies. So the presumption is that it applies all over Arizona, the physical area of Arizona, except for federal areas and some Indian reservations, I guess. That's a presumption. It's wrong. Dead wrong. But let me get to the calls. Been very, very patient. We got Donna in California. Welcome back to the show.
Hi, how are you?
I'm doing well. What can I help you with today?
Yeah, I just wanted to know what 3 things you mentioned last time that I should look at the file.
Okay. And I have templates for this. You have a demur, which is the same as a motion to dismiss. So anytime prior to an arraignment, you can file a demur, which is your way of, it's a legal tool to show that the court does not have jurisdiction to proceed, and the ticket should be dismissed because there isn't sufficient evidence for subject matter jurisdiction or personal jurisdiction. So I think it's the Penal Code section 1004, and for our purposes, the most important part is subsection 4, and that states that there are insufficient facts to set forth a public offense. Now, what they're doing is accusing you of a public offense. They're accusing you of, they're saying that the laws apply and you violated them. That's an allegation. Now, what facts is that based on? Well, you have to look at it as a 2-part allegation. The first part is the laws apply because you're physically in California. The second part is, and you violated them. They don't have any facts, or they have insufficient facts to prove the first part. So the second part's not relevant. And that's why we argue that there is insufficient facts. What goes with the motion to dismiss, because we're basing it on a lack of evidence, and that, like I mentioned with Imran, it's supposed to be an adversarial proceeding. We have had 2 judges in California openly deny that it was an adversarial system. I don't see the critics or anyone saying those judges are wrong. No, they all pigpile on me. Not a single word has ever been spoken about that, how these judges in San Diego both denied that it was an adversarial proceeding. That should scare anybody who goes into that court. So what we do to make it more difficult for the judge to just blatantly, openly deny and arbitrarily deny the motion to the demur is a motion for judicial notice. So the judicial notice is just asking the judge to take notice of what the law is, that the law is, and what the courts have ruled. One of the things the court has ruled on is that it's an adversarial system. So if the judge is going to turn around and refuse to take judicial notice, it's a pretty big due process violation. The judge is actually committing at least a class 1 misdemeanor by obstructing justice and not complying with the laws and taking judicial notice. I want everyone to know that in not one single instance has a judge in California taken judicial notice. They have uniformly denied the motion for judicial notice. And all we have to do is provide, and I do, and if you get a copy, you'll see I do provide the necessary legal authorities. They just deny the entire thing. Okay, so we have that, and that's for use later if we want to have the judge recused. The other thing is a discovery request and a Brady request. Are you familiar with Brady material?
Yep.
Okay, what is Brady material?
Violation of a right. I can't. It's in my notes.
Well, no, Brady.
I'm trying to write down what you just said.
Okay, well, it's all going to also be on the podcast. Well, it's going to be on my YouTube channel here. So, it's going to it's not going anywhere. I won't be pulling this one down
So
because
you could record it.
This is this is on my YouTube channel, which is linked on my website. Of course, it's No State Project, and
Yes, I'm on there.
Right, so you'll be able to get this recording. You'll be able to watch this back and write all this down. Brady material is not the violation of a right. Not getting Brady material from the prosecutor is the violation of a right.
Are you talking about the Brady Act?
No, I'm talking about Brady material, and it's based on a case called Brady versus Maryland. And what Brady material is, it's really important. I mean, you cannot underestimate or overstate the importance of Brady material, especially when prosecutorial misconduct is so rampant in the courts. And that's not me saying it. That's a federal judge. Brady material is information that shows that you're innocent, that the prosecution is, through reasonable investigation has to give you. And okay. Any material that can be used to impeach the competency and credibility of the prosecution witnesses is called Brady material. Now, they have that in Canada, Australia, New Zealand, and England. They just don't call it Brady. They are still required in Canada, for example, to give all exculpatory evidence against you. Anything that shows you're innocent and anything that goes to impeach their witnesses. So my focus on that is that to be a qualified witness, you have to have personal firsthand knowledge of the matters you're testifying to. And there has to be proof. So before they put you on the stand, there has to be proof. Now, it's Rule 702 in California under the Evans Code, 702. Instead of everywhere else, it's mainly 602, state and federal. So my focus on that is the police officer is testifying, the laws apply, and you violated them. Does he have personal knowledge of that? And where's the proof? So there's your Brady violation, that they are not being upfront and honest with you and saying this witness doesn't have personal knowledge. Now, I can say that because after all the experience I've had, when you put the cop on the stand and you ask him for proof of his claim that the laws apply, they will say he's not qualified to testify. They know he doesn't have such proof, but they put him on the stand anyway. Huge due process violation. Some critics, they claim that I'm wrong when I say that is prosecutorial misconduct. And let me explain to you again for everybody why that is misconduct. One way to commit prosecutorial misconduct is to argue without evidence, and to argue and to knowingly put a witness on a stand that there's no proof of personal knowledge. So when they argue that the laws apply and you violated them, they know they have no evidence for the first part, and sometimes they'll argue they don't need it. I say that's misconduct. You're knowingly arguing without evidence. And Donna, I'll tell you right now, if you ask that judge, if you are permitted to make a legal argument against the prosecution, a legal claim against them, and without evidence, would he allow you to do that? Now, do you think you could argue against the prosecution without evidence?
No.
Then why is the prosecution allowed? This is what I'm getting at. That is called misconduct.
That's a due process violation, isn't it?
Yeah, it's a huge due process violation. And in process,
I was just wondering, the videos that you made on standing and the one to impeach a witness, those are still good?
Well, yeah, yes, but I have streamlined things based on experience and going on the assumption that when you go in there, you don't have the luxury of time. You don't even have 5 minutes in an initial appearance. You have to prep as if you're going to get a maximum of 2 minutes before they throw you out of there. And so on a cross-examination, I don't ask the setup questions like I used to. I go right for the throat. He's already testified. He's already done a direct examination. So I hit him square between the eyes because I know what's going to happen. Did you determine on your own that just because you saw me physically in California, that your laws applied and gave you jurisdiction to stop me? And they'll say yes, because isn't that what happened, Donna?
Yes.
Yeah. So you're just trying to get him to restate what happened at the stop, which is fully relevant for any cross-examination. And anyone saying it's not, they're either stupid, they're lying, or they're just being malicious. So then the follow-up question. So this is where we streamlined it to 2 questions. So if you couldn't show before that this was grossly unfair, this will bring it out. Once he says that he did determine that the laws apply because you're physically in California, then you ask him, what facts did you rely on to prove that, to establish that was true or prove that was true? And that's when they jump up screaming, objection, calls for legal conclusion. The witness is not competent to testify. So I've explained this before, but you're new. First of all, the biggest issue here is the prosecutor is pulling a scumbag lawyer trick because you never asked the question there requiring him to formulate on the spot a legal conclusion. You asked him for the facts his prior determination at the stop was based on. You're asking him a question based on his prior statement. He just gave you that statement on cross. He's already testified to that on direct examination that the laws apply and that you violated them. And it's on his ticket. So when the judge turns around and without any argument from you at all and just says sustained, you've got these two working in tandem. This is collusion. They are working together. So even if you bring up, excuse me, I didn't ask a question that called for legal collusion. I asked him for the facts that were in his head at the stop, when he was in his police car, when he made that determination. Why was he doing that? What was he basing it on? And they're saying he's not competent to testify. Now, if we accept that he's not competent, that they should strike his testimony. Every instance of him saying you violated the law should be stricken from the record because he's not competent to say that. But they don't. They don't do that.
Okay, so I'm not quite sure if you were me and you're going to go to an arraignment, what would you do at the arraignment?
I would, when they asked if I was ready to proceed, I would say I am not ready to proceed, that there is a demur pending, and that the demur needs to be determined.
And that would already been filed before that court date.
Well, if you're going to do a demur, it has to be before a plea is entered. Yes.
Yes, like 5 days prior or something. Right.
The rule, the actual rule says any time prior to a plea. So,
okay.
I personally wouldn't, I would get it in there as soon as possible because one of the big excuses that they like to use is, well, the prosecutor doesn't have enough time. And, I'm all for the prosecutor having time to respond. And we, that's hey, that's just only fair. The thing is, this is not a murder trial. You're talking about traffic. Whatever they're going to be using against you, at least for them to make a prima facie case, should be in the file already. The judge should be able to just look at the demur and see, well, you're saying here that the prosecution lacks evidence for X, Y, Z, and I have, and he should just go look at the file, which is only a couple mils thick, and just look at. Well, I don't see the evidence here. Okay, I'll have to sustain the objection, the demur, and if the prosecution has a problem, they can cure it. That's the way things should run. But they you don't want them to. They're not going to do the right thing. They're always going to go to try to bail out the prosecutor. So you get it in there as soon as you can. So it's one less excuse that these people have.
Yes, and well, I just lost my train of thought. Shit. The cop on video stated that because I was in the state of California, I had to produce my papers, and that was false, wasn't it? But she admitted that, though.
That was false. What on a traffic stop
in the state of California?
Well, in their mind, they're thinking the ground. That's why I always strip out the. That's why I always strip out the words of art, or the what I call weasel words, the legal words that have a different meaning in court as opposed to on the side of the street. According to their rules, yeah, if the rules applied, then yes, you were required to identify yourself, and that's why you were charged and might not. And not. I always recommend this. Activism has no place on the side of the street because it's so dangerous. Even if it's not an activist, if you get stopped by a cop, identify yourself. It's under threat, duress, and coercion. There is no rational argument about that. There is no other plausible explanation there. You will go to jail if you don't. So it's under threat, duress, and coercion. And if you didn't stop for the cop, they would have went through the force continuum. Okay, you give them the identification on the threat, duress, and coercion, and then you keep your mouth shut. If they ask you a question, say, on advice of counsel, I'm not answering questions, end of discussion. And you don't say another word until they tell you you're free to go. Your mouth doesn't open, and that's what I recommend.
Oh yeah. Yeah.
There's no way you can talk yourself out of a ticket, even if you are of the female persuasion. It's not even you just keep your mouth shut.
Yes.
So that's how I would and how I would handle the demur. I believe in asking questions and asking leading questions. Yeah, even if people say, well, I didn't learn that in law school. Why would I ask a question in court? Because it's an effective way to defend yourself, and it's a damn effective way showing how unfair the whole thing is. So there's, they probably don't teach you how to put your pants on in law school. Doesn't mean you're not going to wear pants. It reminds me, Donna, of that scene from A Few Good Men where the government lawyer, the prosecutor, thought he was going to get something over. He thought he was going to get something over on him. Where in the law book, where in this, Marine manual do you see code reds? Well, it's not in the book, sir. So he thinks, he's got him. It wasn't in the book. It couldn't possibly happen. It's not in the book. And so Kathy grabs the book on his way up to do cross-examination or the redirect. Say, do you ever have a meal in Guantanamo down there? Ever have a meal? Well, yeah, 3 squares a day, sir. Well, turn to the page in the manual where it says you have lunch. It's not in the code book, sir. You spent 5 years in Guantanamo. You never had a meal? No, 3 squares a day, sir. See, just because you didn't learn something in law school doesn't. Hey, they didn't. I'm pretty certain they didn't teach as a valid legal defense the Twinkie defense. They still use it. So the idea that just because a lawyer didn't learn it in law school, or lawyers typically don't do X, Y, Z, is not a statement that the tactic has no merit and shouldn't be used. Because I just, since you're new, bear with me for another moment. What I suggest doing is very simple and easy to understand. A little more difficult in the execution, but not so much. We want to challenge the assertions and the claims being used against us. Does that sound right?
Right.
Okay. We don't want to give the prosecution a free pass. So should we give the prosecution's claims a free pass? Should we just accept it as true and not challenge it? Does that sound reasonable to you?
No, you got to question it.
You got to. So we're not going to give the prosecution any free passes or sacred cows, right?
No.
So the third part of this is we are going to challenge the very foundation of the prosecution's case, and that is the laws apply and you violated them. Now, this is where people go off the rails who disagree with me. They will, just like you, agree there should be no sacred cows. We shouldn't give the prosecution a free pass. But then when you bring up what the actual foundation of the prosecution's case is, all of a sudden the heads start exploding. Oh, no, you can't do that. You're an idiot, frivolous. So their whole position against me is contradictory. Well, we agree you should challenge the prosecution. We agree you shouldn't give the prosecution a free pass on any of his claims. But we're going to contradict ourselves and say, well, on this one, yeah, on this one, you should let it go. No, I want to be logically consistent. And I want to do what's effective. And the benefit that you and new people have that are coming to the show is that you have the benefit of seeing how the material has been used before and has been replicated. Now, does that mean that there are no train wrecks? No, I report on the train wrecks all the time. In fact, my last video for success stories included a train wreck. In fact, that's the thumbnail on the video. You can go into court and you could be absolutely annihilated. You can go to court and you go to jail. But that's not unique to working with me. Hell, there were 45 some odd people in New York that went to jail for contempt because a cell phone went off and nobody would drop a dime on the guy whose cell phone went off. So just going to court in and of itself, there's a risk of going to jail. You don't have to be a litigant. You could just be walking through. So
I know. I used Rob Johnson's stuff. This was years ago in a case in Markleyville where I challenged, or I didn't put in a plea because I turned around and asked for if there's anyone present to put a claim of harm or injury against me. And I did that 3 times and turned back around and said, Your Honor, I can't put in a plea because there's no victim placing a claim of harm or injury against me. And he was practicing law on the bench and put in a plea for me. First, he cuffed me up and put me in a room for 5 or 10 minutes.
Sure.
Took my purse, tried to go through my wallet, took my camera, and tried to force me to make a plea. And I objected for him putting in a plea on my behalf and practicing law on the bench, and told him I was gonna to take me to jail because I'm gonna sue you for practicing law on the bench and violating my rights, and sue this deputy for trying to steal my property and falsely arresting me. It went on and on and on and on,
Sure.
and I don't want to do that anymore. You understand?
Well, you shouldn't do it that way.
Have it anymore to go through that anymore.
Well, you shouldn't be doing things that way. First of all,
No,
if
that
you
was when I first started learning.
yeah, and thank goodness.
But they uncuffed me after 15 minutes.
Oh, thank goodness it was only 15 minutes, not 15 days. They could have entered an order to have you held for a psych eval because you're doing sovereign citizen or sovereign freeman on the land type of things. One of a lot of misconceptions here, and I know you're not doing it. Just for people who are listening, because I haven't noticed it, but people, I tend to get some patriot types, occasionally here. If you openly refuse to enter a plea, now I may agree with your standards for doing so, your prince, but it's not a good tactic because according to their rules, it's not practicing law if he enters a plea because he's just following his code. So even if it's considered the practice of law to enter a plea on your behalf, it's not considered a crime or a wrong that's actionable by you because he's just following the code. That's why one of the things that because it's actually, I send you 4 documents when someone buys the templates. I recommend going in, and so that they can't legally enter a plea for me, I tell them that if they refuse to hear the demur, the motion to dismiss, and they just want to force me to plea, I tell them I intend on pleading guilty. Does the prosecution have sufficient facts to meet their prima facie burden on jurisdiction? It doesn't mean that they're not going to just enter a plea for me anyway. But
What did you mean by prima facie?
Prima facie is the Latin term, is at first look. That is a much lower standard of proof than at trial. Trial is either beyond a reasonable doubt if it's criminal, or preponderance of evidence if it is civil. Here we're talking beyond a reasonable doubt, but the prima facie is they have to have a minimum number of facts, which, if true, support the allegation against you. Now, I don't believe that they can do that because they're assuming that the laws apply. That is an assumption. I even have it on record saying that. So that's why it goes back to the demur I mentioned, insufficient facts. I don't believe that they've made their prima facie burden. They've met that burden, because just alleging that I'm subject to the law doesn't prove it. And the only fact that they have is my physical location, but that fact is grossly insufficient to prove that the laws apply. Because one example, like Imran said, my physical location in California does not prove the laws apply, because it doesn't apply to diplomats. It's not sufficient to show that the laws apply. Plus, it's a written instrument. So how does my physical presence here, my physical being here, how does that prove a written instrument from 1879 applies to me? Well, it doesn't. It doesn't even come close. So that's what the prima facie means. They don't have sufficient facts to even at this level shift, have a presumption of correctness and shift the burden to me, where I would have to show facts, contrary facts. I have a prosecutor who's pulling that crap, and I'll get that posted during the week in my response.
So you don't bring up anything about injury, right? Or violating a legal right.
Well, that is in the demur. That's in the demur already. And so it's not just that we're saying.
So it's already in there.
Yeah, but remember, it's not just that there's no allegation of that. Even if they look, they are alleging a legal injury, and that legal injury is you violated the law. That is their legal injury. There's no evidence to prove that the laws apply for there to be an injury, because the actual legal injury is the laws apply because you're physically in California and you violated. That's their claim of legal injury. There's no facts to prove that. So if we are trying to plead guilty, and all we're doing is asking if the prosecution has sufficient evidence, which we're doing through the demur, because some people say, well, you can't ask that. That's asking for legal advice. We have a demur in place. The only way to deny or overrule the demur is if the prosecution has met their burden. And we're supposed to be entitled to be informed and enter a voluntary and intelligent plea. If the judge is saying that he does have sufficient facts, what facts are you referring to? It's not asking for legal advice. What on this complaint, other than is it your position that my physically being in Riverside, or I was in Loma Linda for quite a while last week, is it you're in Jackson? I just remember. So is it your position that just because I'm physically in Jackson,
you're a smart man,
that just depends on who you're talking to. Is it your position that because I'm physically in Jackson that your constitutional laws apply to me? Critics will say you shouldn't ask that. You can't ask that. Well, one, we can because I do it all the time. Two, it's proven to be really effective.
You wouldn't bring up the vehicle code she used as if that applies to me either.
I don't care about the vehicle code, because just like when I'm talking to the IRS or I'm talking to the California Franchise Tax Board, you have to look at it logically. What is the authority for the vehicle code? It's the Constitution, right? Donna?
Yes, yeah.
Yeah. So if you listen to my Call of Shames, I've had one that's recent. I may have mentioned to you before. I ask if they have any that they're operating under the presumption that if I'm physically in California, the laws apply and give them jurisdiction. So I say, oh, do you have any proof that just because I'm physically in California, your Constitution applies? And they'll say we have the Revenue and Taxation Code. So I will then follow up and say, so is it your position that the Revenue and Taxation Code is somehow evidence that the Constitution applies? It's not the other way around. Isn't the Constitution evidence that the code applies? And they'll, well, yeah. So I don't get the code and mention the code unless they do. The important thing here is we are going right at the foundation of the prosecution's claim. Their claim is if you're physically in California, the laws apply and give us jurisdiction. I don't have to mention the code because the code depends on the other.
A lot of times when you fight a traffic ticket here, there's no prosecutor. There's just a judge and the cop.
Well, the cop is
if
acting
it
as
shows up.
yeah, but the cop is acting as the prosecutor at that point. Like they do the same thing in Arizona. The cop is the prosecutor. That's his job. He's not just a witness. He is there prosecuting.
But but the cop is incompetent to answer legal questions.
Damn right. They'll do it we had one case recently where the judge allowed the answer to the question. One case in the entire time I've been doing this that's been reported to me. One. So I have to say that.
This particular cop is an idiot.
You look, every profession has their idiots. He may be.
I mean, she was shaking. Her hands were shaking when she handed me her ticket thing, where she wrote the date of the ticket 10/48/2019. Wrote 2011 for my truck year, but that's all got amended right now.
Well, they've held it.
They can lawfully amend it.
Mm-hmm. They've held that they hold that for them, harmless errors like that. It could be something, really bad, but for them, they allow it. Imagine how she would shake.
Her hands were shaking so bad when she handed me the thing.
Imagine how she would shake if you're standing in open court or she's on the witness stand and you ask her, you determine on your own that just because I'm in California that the laws apply, that gave you jurisdiction to stop me, right? And she'll say yes. Imagine how the blood will leave her head when you ask her, what facts do you rely on or did you rely on at the stop to prove your claim that just because I was in California, the Constitution applies to me? She'll go white.
She's not gonna know what to do.
She's gonna look at the judge. She's gonna
yeah,
you got my back here? And the judge, as this servile people that judges are, they are company men through and through. He is going to say, calls for a legal conclusion. The witness is not qualified to testify. And you can say,
I pretty much followed that standing of the video that you have out.
Not at that point. At that point, you want, I would argue, excuse me, sir. The question asked for facts that their prior determination was based on. See, when we ask them, did you determine the laws applied? All we're doing is having them restate what happened at the stop. What was in this idiot's head, use your phrase, what was in her head that caused her to do that? So asking them on cross-examination about what was in her head.
She changed her mind when she saw me recorded the GPS trip of the whole trip from speeding to unsafe lane change, using my signal,
Yeah, you like I mentioned on the show, you could put her on the stand, and after you have the judge declare her incompetent, if he doesn't cut off your cross-examination right then and there, now you can go into introducing your GPS evidence and nailing her on a false report. Of course, look, it might get your case.
She changed her mind. And the chief of police agreed with her, saying that she stopped you for speeding and unsafe lane changes. And I says, well, if that was the case, why did she not write me a ticket for the speeding as well as the unsafe lane changes?
Yeah, well,
why did she change her mind?
That's a subject for cross-examination.
I already know why she changed her mind.
That's a subject. Yeah, well, you want to find out, but you can still prove she lied about speeding.
And guess what else I found out? That during the stop, which is considered investigation, active investigation, with her and her buddy that had his hand on his weapon the whole time he was out my window, she turned off her body cam in the middle of it.
And I didn't get a chance to call down to Jackson, but that's something you can do, is find out about the policy for turning that off. I did an initial research on that, and it's something. It's not published. It's not like Los Angeles where it might be published online. Jackson is so tiny. You're going to have to get in touch with the police department regarding.
Yes.
So I'm running out of time. but I am running out of time, so I can address one more question.
I was just wondering if I should bring up the bond that the people get in my name during court, and to have them settle the debt as me as the creditor, or that wouldn't work at all, would it? I know you're upset with me now. I just wanted you to just say that is the sovereign citizen bullshit, right?
Well, let me ask you this. Are you actually watching the stream?
Yes.
Okay.
I know. I look on your face. You're
for
shaking
some reason,
your head. No, no, no.
for some reason, I was under the impression you were just on the phone. I didn't mean for such.
No.
Okay, you caught me. Well, let me ask you this. What proof do you have that such a bond exists?
Well, see, I thought they'd put it in my name and take control of it to make the money off of it when they screw me out of my money.
But what I asked you, and this is something that you want to do whenever you question somebody, you want to get a responsive answer, especially when you're dealing with these people. What proof, if any, do you have that support that claim that they are creating a bond?
I just thought that everybody would have to have a bond for protection in case if you do harm to the next person, right? The prosecutor could do me financial harm.
What is that? Yeah,
which they do every day.
But they have self-insurance. In fact, I know that the county.
Oh, okay.
I know the county has insurance. I haven't found it yet.
They have
Jackson.
in-house insurance.
Yes, but they also do reinsure, where a lot of times, like they do this in Arizona, in Phoenix anyway, where in Scottsdale, where they are reinsured by a private insurance company, or like Scottsdale, for example, self-insures up to, let's say, $1 million, and then over $1 million, it's covered by a private policy. So, but what does that have to do?
The chief of police admitted that none of his officers are required to have any insurance.
Right. They're not. They are not. That's something that I want to, to pursue as, but that's for another show. I don't have enough time to get into that. They are under the city or county's insurance. So every single county employee and city employee will be covered for damages, even judges and prosecutors. They are covered by the county or city's insurance.
It's a house insurance then.
I'm sorry?
So it's a house insurance, where it covers everybody in the city.
Well, it covers
or the county has a house insurance and it covers everybody in the county.
Right. So that and they've done that for quite a long time. So again, I think the answer is obviously, so you don't have any actual proof that they're doing these bonds.
Well, the thing is I when I was almost killed by a sheriff deputy in the middle of the night, for asking for their policies and procedures, I got all their bonding information from the county, and this other guy says when it's a house bond for the whole county, that leaves the liability up to for the clerks, the police officers, all them people. Wouldn't be actually protected.
But
personally,
Donna, having a house bond or a blanket bond for county employees doesn't mean that they're creating a bond when they arrest somebody and prosecute them, does it?
No.
No. So again,
I don't have any proof that that's what they're doing.
There you go. And until you have proof, I
can't accuse anybody.
That's right. We're not going to do like they do and claim, and all their minions out there who live in houses 5 times as expensive as mine, who have multiple cars and vacations. They're the ones where it's lucrative. They're not going to challenge it. They are the ones that argue they don't need evidence, but we are going to act in good faith, regardless of these people on YouTube. we're going to act in good faith, and we're not going to make accusations, and we're certainly not going to defend ourselves in court against these criminals by raising issues we admittedly have no evidence for. So for everybody listening,
Yes.
and I've challenged people to do this, call the show with the evidence of these bonds. No one's able to do it. And yeah, Carl Lentz was on the show 6 times. He wouldn't answer my question. On the 7th try, he eventually said, well, it's my theory. So we're not going to do things on theory. We're going to do things based on the evidence and based on logic, and that has been replicated in the past. So that's something that I do offer. So yeah, we don't want to pull any of that crap. All right. So let's not have any. Don't make me facepalm again, people.
Oh, geez, I felt bad for you.
I couldn't see. I couldn't even see this. I couldn't see the playback, so I didn't. I just. But
it was horrible. It was horrible.
But
hey, it's just that people like us, when we first start to learn these things, there's so many places that people that it really sounds good and right. It makes sense on how some of these people actually convince you that this is what's going on.
Yeah.
And for me, I had to stop the studying for a long while because I literally got physically sick.
Well, that doesn't sound fun.
It affected me that much.
Well, the thing is, we get the ball rolling, just by learning to ask questions. And when you ask a question, have an idea of where you're going with it, and only accept a responsive answer. I was nice to you when I wasn't unprofessional when I called you out on that. I just restate the question, just an answer. So eventually, we got to, you said, yeah, there is no evidence, which is what I was going for. But that's what you want to do. You want to ask questions. What about this? What about that? Well, my gosh, a bond. Well, that sounds like a paper trail to me. It sounds like, they talk about the birth certificate.
To verify and what's true and what's not, because there's so much crap out there,
It's like I said in the last few shows. Don't believe it unless you have the evidence and the logic to prove that it's true, that you've questioned it a number of different ways.
The only thing I think is true is what I found on Department of Justice website. And it talks about all cities that are incorporated, like Jackson is incorporated municipality. They must register it's called a registration statement pursuant to the Foreign Registration Act of 1938 as amended. And I'm not quite sure if that is true or not, but they're required to fill out a form, a short form.
I'm not familiar with that. That's something you'd have to send me some details on, and we can discuss that another time. I do have to get at least another caller in.
Okay. Well, that's okay. I've been hogging the station.
Hopefully it's no problem. I do appreciate the call, and hopefully I don't have to face palm for the rest of the show.
No, I hope not. Thank you.
We appreciate the call. We'll go to Home Bumming It, who had some damage control that we can call a success story. Welcome back to the show.
Thank you. How's it going, man?
You going to make me facepalm?
No, I'm not going to make you facepalm. No, why? I'm already done in court, man. You got using the your methods. 4 misdemeanors gone. No fines, fees, time, nothing. It's and the damage control. I was taking that plea deal, so it's farther than any public offender would have gotten me.
Yeah,
so
I think that's great. I think that's great. I just I'm glad it came up. The stuff she was talking about. It's an opportunity to help her better identify bad arguments and how to challenge people effectively to bring that out, and that you can do it without. I don't think I came across like a douche. I think I was professional and courteous to her, and you still have to call somebody out calmly and rationally on a non-responsive answer. You don't get it. So that's what gets me too, home bumming it. When you watch or listen to mainstream media, and if they're interviewing, especially a politician, 9 times out of 10, the politician doesn't answer the question. Now, occasionally you get somebody, even on Fox News, Chris Wallace. I've actually seen him more than a couple times in the last 6 months, actually calling a politician. No, you haven't answered the question. So,
well, I don't recommend watching television. It's just me, you're gonna get ulcers from doing that, man.
I got to spend more time with my Les Paul. I know.
It's all good. Do me a favor. Someday, will you go ahead and actually play 5 minutes on the guitar on your way out? At the end of the show or something.
Do you know the crap storm that I would get for doing that? I'd have to block the comments.
No.
Oh, the hate that I would get. One day I will. I'll plug the amp directly into the mixer. But it's funny because
screw 'em.
I felt, I know. I was practicing yesterday, and we have this as my daughter's guitar, and it's no secret that I love Peter Green, and so I was just playing a couple licks, Peter Green licks, and I broke the E string. Like, damn it. So I have another one over here. And so I figured, all right, I'll just pick up, and keep playing. And a couple of minutes later, bang, I broke the E string on that too. Like, son of a, what the? No, I didn't break the one on my Les Paul though. So now I got 2 E strings to replace. But I know this probably has nothing to do with what you're calling about, but someone just posted this, and it got me, because one of the things I think I mentioned on the show, that Facebook and YouTube, because they want you to be monetized and pay, they don't notify all your subscribers. And I got to tell you, I do appreciate the bit of support I get for the show. It's actually, it's not an extravagance, of course, because why, look at this. But someone, I think Verbal Armament, made a really good point. And so I don't know, there's a lot of comments, so you may have missed this. This is really disheartening, because the cop blocking guys get like 10 times or 100 times the views that I get. And I honestly can't, I can't watch a lot of the stuff. And so he said there were 70 people.
Neither can I.
There's 70 people on here. Bao had more than that, and all he did was sit in his backyard, looking all hammered and stoned off the money people donated to him. And I get it. I'm really toying. I can't do it with this show because the tech issue. I can't record. I'm stuck with the feed. But once I get that straightened out, maybe what I'll do with the Saturday show, or if I learn how to use Twitch or something like that, I can stream and I could do the show as I'm playing a game, like Pac-Man. And just as a social experiment to see if the number of views that I get jumps up.
Well, the thing is that a lot of people, and I don't get a lot of views on my stuff either. But the thing is that people want entertainment, and they want train wrecks, and they want sensationalism. And a lot of times you were even talking over my head. It took me a long time to realize that jurisdiction is the rightful use of force, and that law is force. So you're asking them, what facts and evidence are you relying on to use the law against me? And, people don't, then they don't believe you. either unaware or they don't want to be aware and they just want entertainment. And hey, let's watch this guy get shit faced in his backyard. I mean, that's
but
what they're going for.
I posted something a number of years ago.
Substance is not popular.
What's not popular?
Substance is not popular.
Well, I'd like to think that was true, but it's not, to explain my situation, because, you have something, the History Buffs is a great channel. I think a great channel is Criminally Listed. I think the guys,
Cody's Lab. I know you like that one.
Which one?
Cody's Lab.
That's not ringing a bell.
Cody's Lab. You went ahead and you said Cody's Lab was a good one, where the guy's going ahead and he does gold refining and basic chemistry.
I never said that. You're thinking of somebody else who's got you're thinking of somebody else who only gets 1,000 views.
Okay.
No, that's not me. Yeah, there are a few channels that have, to have substance. I mean, the guy who does Criminally Listed, or the guys who do Criminally Listed, that's a great channel. And I mean, and it took a while for it to take off. I mean, all of a sudden he went from 80,000 subs to 400,000. So, and he has extremely well researched stuff, and he doesn't do and I'll tell you this, he doesn't do that crap that a lot of the three mysteries. He doesn't just read from, what is it? Like they do the channels that they just literally read off of Reddit and get millions of views. He actually researches and does things that you've never heard of before, where all these other top 3 or top 5 channels are rehashing the same thing for millions and millions of views. And I'll tell you this is another big one. He doesn't use those stupid things on the thumbnail with the big red arrow and the circle. He doesn't use gimmicks. And I tell you, my position is, unless I know the channel, I absolutely will not click on a video, regardless of what the content may be, if they pull that clickbait crap. I hate that crap. There's one guy, there's one simple thing in the thumbnail, and there's a big red circle around it. What the? Millions of views, or at least hundreds. They're making, and someone said that one of the richest kids on YouTube, one of the richest people on YouTube, is a little kid who got millions of views. He was opening up a toy.
Yeah. Well, I mean, come on. You look at like PewDiePie. What did he do? He was basically making videos of him playing video games and then reacting to other people's videos. That's how he got to be so big on YouTube. And most of the things that are watched on YouTube are either mainstream media or they're BS entertainment. You're more educational. Like I said, there's substance here that a lot of people don't. As far as that one guy, I don't know what channel you were talking about, and I'll look into it. I'll watch the video again and look into it and see what the deal is.
Yeah, I don't know. But
yeah, well, no, I don't understand humanity either, man. You got me, man.
Yeah, it was like a number of years ago where I saw that James Burke's Connections had 1,000 views, and then you could see something really stupid with millions of views. I'm like, James Burke or Connections? Are you kidding me? One of the greatest documentary series ever produced in history, James effing Burke? Really? Hey, wherever you have to get it, if you go to Terrarium or something, if you haven't seen Connections, definitely check it out. It is fantastic. But did you have any questions?
Yeah, I did. Okay, so I'm kind of working on my I'm brushing up on civil code and trying to outline a case for a civil suit against the store and the security company. And the thing is that since I don't have any medical bills from getting hit in the head, the guy cracked the frame of my cheap sunglasses when they fell off my head after he hit me in the head. So all these lawyers are telling me that, oh, your case is useless, you can't get anything for it or anything like that. Well, me and JC were actually talking about this yesterday. So I was looking at exemplatory damages or punitive damages, right? Under California Civil Code 3294, in an action for the breach of obligation not arising from contract where it is proven by clear, no, that's not it. Any employer shall not be liable for damages pursuant to subject A based upon acts of employee of the employer unless the employee had advanced knowledge of the unfitness of the employee with employed him or her with a conscious disregard for the rights and safety of others or authorized or ratified the wrongful conduct for which a damage are awarded or was personally guilty of oppression, fraud, or malice. Now, here's where the caveat comes in. With respect to a corporate employer, the advanced knowledge and conscious disregard, authorization, ratification, or act of oppression, fraud, or malice must be on part of an officer, director, or managing agent of the corporation. Now, we both know that the assistant manager said that I had a history of theft from that store. That she actually said that she never stopped me personally from stealing anything, but she said that they knew that I was stealing from the store. That's absolutely not true. So under the definitions, Section C, as used in this section, the following definition shall apply. We're looking for malice, oppression, or fraud. It would actually fit under oppression and or fraud. Oppression means despicable conduct that subjects a person to cruel and unjust hardship in conscious disregard of that person's rights. Oppression. So that was oppression. Then fraud would be means an intentional misrepresentation, deceit, or concealment of a material fact known to the defendant that the intention of that part of the defendant of thereby depriving a person of property or legal rights or otherwise causing injury. So the fact that they went ahead and they said that, oh yeah, they knew that I was stealing or whatever, but they had no evidence or anything like that. And she's just kind of making things up. That would fit into these categories.
Yeah,
but I'm having a hard time.
Well,
go ahead.
But I think maybe where the lawyer was going is that can you prove the damages? Other than, I mean, can you prove the physical damage?
Can I prove the physical jam? Well, this is California Civil Code number 12, which basically states that it's under their jurisdiction to deal with issues or civil procedure is to resolve issues of either a violation of rights or harm or damage. So they violated my rights to leave. They went ahead and I was assaulted and I was battered. As far as damages, physical damages, there's not much of it.
That might be why.
That's what I think they're counting on.
Yeah, well, that might be why they're saying there's not much of a case there.
But there's oppression and fraud.
Yeah. You
on behalf of the store.
You still have to show that it damaged you.
Well, I think they emboldened the cops to go ahead and make their false arrest.
No, can you prove that?
That's a good one.
And that's where it turns. You have to be able to prove it. So even if it's minor damages, I think a claim against the city's insurance is probably the better way to go.
But wouldn't the fact that I went ahead and I took the plea deal negate all that?
It might. You'd have to take a look at the plea deal. So
What would I be looking for?
you have to be looking for something in there that you're holding the city you're not holding the city responsible for any damages.
Well, it'd be the county, but
Well,
yeah.
the county. Yeah. But bottom line, yeah, you know, like, I mean, I asked if you can prove it, and there was this long pause, and then you said, well, that's, it wasn't so much confidence. And that's the thing is, we have to be able to prove it, and that's probably why the attorney was, hey, just based on what you've told me so far, I'd say the same thing. Either you right now, from what you've told me, no, there's nothing there. If you come back in a week or two and I asked you that question, well, hey, can you prove this? And you say, yeah, because I now found XYZ, then it's a different story. But until you're able to prove it, then no one's going to help. And it probably wouldn't be advisable for you to go ahead anyway. You got to be, you can't be like the prosecutor and just make an allegation and try to claim, well, I don't need any proof.
Well, I got proof that I was hit in the head and that I was assaulted, and that's a violation of my rights. Isn't a violation of my rights, and actually that would be also a civil what do they call these?
You have to, all right, at least we're getting back to the, all right, you have to have, for an adversarial proceeding to be subject matter jurisdiction, you have to have injuria et damnum. You have to have the injury and the damage, and of course, the court has to be able to redress the injury. So there may be damages there since they hit you, as long as you get, but you have to prove that the damage was caused by, in part because of what the store did by having, you have to be able to prove that. So I'm pretty much out of time.
Well, the security guard also didn't have a guard card.
That might be something to look at too. So there's negligence on the part. You have to build your chain of causation, and you have to show that not only are the police on there, but you have to show that the store is in that chain of causation. And if at any time that chain of causation is broken, then you're not going to have an action against against the store. So the chain of causation is critically important. If you can't show a full chain of causation from A to Z, you're not going to be able to maintain an action until you're able to prove that chain of causation from A to Z. Then you're SOL. But I am at a time. I did go commercial free for 2 hours, so I got to let you go. But
Thank you.
We'll be in touch off air. Okay.
Yeah. Email or whatever.
Yeah, or email
Discord
or Discord.
too.
Yeah. So I appreciate the call.
All right. Have a good day.
Thanks. I can drop off of there. Take this stupid thing off my head. Gosh, I hate having that stupid thing on there. Well, blues. Yeah, you want me to break the E string on my Les Paul? Somebody did ask, is there live footage of me playing guitar? Yes. No, I didn't miss the Easter. I was Andy. There was a train wreck at the beginning of the show. I missed the first hour trying to get on the LRN stream, and it didn't work out for today. So we do have we have the same amount of new material. So there's that, and I will not be taking this video down because I didn't get a remote recording of the audio. But as far as live video of me playing guitar, yes, there is footage. Um, it goes. Spencer Morgan had come down for the workshop, and we had planned a jam ahead of time, so I had my guitars, and he came down and did a great job on lead guitar. So if you go to Spencer Morgan's channel on YouTube, you have to go back a bit, but that is in there. I used to have it linked. It may actually be at my website under the. If you go to the store and then you go to the workshops, it may be there, but you should be able to get it by looking at Spencer Morgan's. What I'll do is I'll take a look for it too, and I will post that if I could post that link. I'm not going to play any today because it's not hooked up. Really not interested at this point of the flood of negative comments because I will one day, but not today. But I do appreciate everyone tuning in to the big show today. If you want to help support the show, it is really needed. Not just to buy guitar strings. That I wouldn't do that. But you can go to markstevens.net and markstevens.sells.com. And if you're being attacked by a bureaucrat and you want a proven effective way to be able to defend yourself against these tickets, of course, there's no guarantee of any success, but you can see what we've replicated on a regular basis. Then check out Government Indicted. I also have scripts and templates available. But I will be live on the Wednesday show, Odin willing. We have no more tech issues. So till then, salud.